Good morning, Mr. Collins.
Good morning, my lady. May it please you, my ladies and my lord, in this matter I'm here with Mr. Derbyshire on behalf of the appellant and Mr. Moynihan and Mr. Burton here for the respondents. Would it be convenient if I highlight a couple of matters from the supplementary bundle in relation to the history of this matter?
Well, of course, but I should have said in the first place that you can expect and understand that we have read widely in this case.
Yes, my lady, of course. The at tab 1 of the second bundle is the order appointing the court-appointed receivers, and at tab 28 of the authorities bundle is the judgment of the learned judge on that occasion, which of course sets out that their whole raison d'etre is to sell things, and also sets out the expertise of the receivers being appointed, both as licensed insolvency practitioners, but licensed insolvency practitioners with expertise or at least experience in relation to the football field. And the receivership interests are set out on page 9 at the end of the order. The second respondent, only one order was made in relation to Mr. Oyston's assets, which was his controlling shareholding in Denaxe, and all of the other orders were made against Denaxe, the first respondent, and they related to what were broadly described as the football assets, being the controlling shareholding in the club, I think all the shares in the associated hotel, and various properties, including the stadium and a training ground some little way away in Lytham St Anne's. Now, what then happened, as you'll have appreciated from the chronology which was set out in my skeleton argument, was that pursuant to the power that was given to the receivers by having under their control Mr. Oyston's shares in Denaxe, they removed the board of Denaxe and appointed their own people. In particular, if we look at tab 2, a file note which was produced after the event by one of the receivers, a Mr. Bolingbroke, and his job, as we see from lower down on page 10 at paragraphs 8 and 9, was, apart from running the club because he had special expertise, was to assist in the sale of the club and to assist in the due diligence exercise to complete the sale. And
by the expression club, which also appears in the judgments, you understand that to mean the whole shooting match? What enables people to go and kick a football on the field on a Saturday?
Yes, because I suppose one might term it the footballing assets, because everything was sold as a package. Yep. But of course, the club itself was a separate company, subsidiary of Denaxe. Because if we look back at page 9, under the receivership interests, the receiver was appointed over Mr. Oyston's controlling shareholding in Denaxe. Yeah. And then in relation to Denaxe, the first respondent, it then had a receiver appointed over its assets, being its, what was then 76% in the club, 100% of the hotel, and a number of properties owned by Denaxe.
Well, sorry, okay, I just want to get the terminology. There's no particular point, substantive point in this, other than we need to be clear at the outset. There, you identified the words club with just Blackpool Football Club Limited, whereas in, I think, maybe Mr. Justice Fancourt's judgment, I think, but certainly the club is used much more generically to yes, encompass a broader spread of things, not just Blackpool Football Club Limited, but in other words, the footballing assets.
Yes, my lord.
And everything.
Of course, this isn't our note or my note.
No.
This is from one of the receivers, and I think that is the way in which he was.
Well, I think so, because if you look, he defines the companies at the top of the page.
He does, and so he's talking about the club in the way in which everything, all the football assets, as your lordship put it, the means to play football.
Sell everything together.
That's right, and that was always what was envisaged to sell the thing as a going concern, which is one of the problems with what actually occurred, and the negligent undervalue, or at least what his lordship has found below as to be my arguable case as to negligent undervalue. At the top of page 11, it's repeated that in the second line, MB, Mr. Bolingbroke, provided significant value added in the roles he performed, in particular negotiations with Mr. Sadler, very sensitive given the completion of the underbidders, the complexion of the underbidders, and his role in this part of the receivership was paramount to the successful sale. And we also have the benefit from Mr. Cooper of an early email to Mr. Bolingbroke, further on down the page, right at the bottom of which, before the little arrows, it says one of his critical points under B, about 5 lines up from the bottom, is work to get the club into a position that it can be sold. So the whole purpose of Mr. Bolingbroke's appointment, with the appointment of the new board to Denaxe, was to achieve the sale, which was, of course, the purpose of the receivership. Now, where this present story starts is on page 14 with the application notice, which started the ball rolling to the application, the blessing application at the beginning of June. This is the 10th of May. And what was sought in paragraph 1 of the order was permissive to sell the assets set out in the schedule to the attached draft order as part of one transaction. Now, we don't actually have the attached draft order, but what was in the order appears from page 17, which is the second page of the witness statement in support of the application. And
Page 17.
Page 17.
Thank you.
And at paragraph 2.1, you see that what is sought to be sold is all of the things which the receiver has possession of, or is appointed in respect of. Denaxe's shareholding in the club, properly so-called BFC, the stadium, other football assets, including the training ground and a car park. And then lastly, something that they don't have, which is the petitioning minority shareholders' ordinary shares in BFC. And that was what was being sought. And we see that the whole reason that this was being done was because nobody wanted to buy the football club and the related assets when there was a prospect of Mr. Oyston becoming a minority shareholder, which he would do once he had satisfied the buyout, the money part of the buyout order, which had been ordered on the 994 petition. He would, of course, have bought out VBFA's minority 20% shareholding, and nobody wanted Mr. Oyston as a minority shareholder. And so this was the reason, as we see from page 24, at paragraph 29, on the basis of the position taken by prospective purchasers to date, i.e. they don't want Mr. Oyston as a minority shareholder when he acquires VBFA's 20% minority shareholding pursuant to Mr. Justice Marcus Smith's buyout order at the end of the long 994 trial, it will not be possible to sell Denaxe's shares in BFC unless VBFA shares are also included for the sale. It is for this reason that the receivers are making the application. Now, just as a matter of detail, the learned judge below, because I think we didn't give him, mutually did not give him sufficient assistance in relation to this, recorded that application and that evidence had not been served on Mr. Oyston, but in fact it had been. Just as a perhaps not unimportant point of detail, perhaps not unimportant for the learned friend's purposes in any event. Now, we then have a confidential exhibit to Mr. Cooper's evidence in support of the application, which was dated the 10th of May, but we did not receive this confidential exhibit until the 20th of May. And in it was the one that set out much more detail about the sale process. His witness statement in support was somewhat generic, but this one set out details of what they'd done, and that's why it was all confidential. And we didn't get it until the 20th of May. By we, I of course mean only Mr. Royston, because we're not in control of Denaxe. The new board appointed by the receivers are. We didn't get this until the 20th of May, following the order which was made on the 14th of May, when the application first came before the court. Now, at tab 6, page 19, is the judgment which was delivered when the matter came first before Mr. Justice Marcus Smith on the 14th of May. And you can see that the only people...
Sorry, just give me that reference again.
Page... oh dear, wait a minute, there's so many page numbers on this. It's page 35, my lord. Yes, it's the page numbers that we should be on are the ones which actually use the word page. Page 35, tab 6.
Yep.
Now, on this occasion, His Lordship delivered a short judgment. The receivers were represented. VBFA, the then minority shareholder, was represented, but nobody else was represented. And this is a not unimportant judgment, because if one looks to, first of all, it sets out what the urgency is at paragraph 5 of the matter, because it's something to do with the annual general meeting. But at paragraphs 6, 7, and 9, the word approval is used in relation to the sale. Second line of 6, last line of 7, and the last few lines of 9. Now, that is rather different from what was sought in the application, and for this reason, that's why I'm making the application from Mr. Cooper. But we did not receive the transcript of this judgment until late in the afternoon on the 4th of June, which was the eve of the hearing, the substantive hearing before Mr. Justice Marcus Smith. What we did receive earlier is the order that was made on the 14th of May, which is at page 38, tab 7. And there's been some controversy about whether this was whether this application was in fact served on the last two respondents. No, the first and fourth respondents. The Denaxe itself and its subsidiary, not wholly owned at this point, the club. But what His Lordship concluded below in relation to this controversy is something which one couldn't really take issue with, and that is that he said that the right conclusion to draw is that at the time Denaxe knew of the sanction application and supported it passively. That's what His Lordship says below at the end of his paragraph 41 of the judgment below, and that, with respect, I think is the right answer, because of course it's most unlikely that Denaxe would not know of this sale, because that was the whole purpose of appointing the new board to Denaxe, including in particular Mr. Bolingbroke, to achieve the sale. So I think formal issues of service are probably neither here nor there. And what was provided for by the order on page 39 is that, of course, VBFA would have been most unwise to have sold its shareholding without more, because it would have undermined its ability to meet the buyout order which had been ordered at the trial. And so it sought an order varying the final order at trial, so that it was at liberty to sell its shares and merely just to take money, take a money judgment from the trial. Now, that we opposed, and we sought permission to appeal but did not get permission to appeal. One doesn't need to really dwell upon that issue, because that's
The way I understood it, it was envisaged that if it sold its shares as part of a composite transaction, the receivers
would account for it.
would, as it were, take the money,
Yeah.
discharge whatever needed to be discharged, and then pay it to it as a judgment creditor.
Well, I think it might have been a little bit more complicated than that, but because of course there was an order.
The source of them, sorry, the source of how VBFA is what it's called.
Yeah.
The source of VBFA being paid its judgment debt would be through the receivers.
Yes, yes, absolutely, because that was the purpose of their appointment.
Right. So
by way of what is called
as opposed to pursuant to the original order, which was the buyout order.
That's right. Yep. But of course, what VBFA wanted was an order varying the order at the end of the 994, so that when its shares were sold as part of this composite package, it would not be undermining that order. Yep. So that we could somehow ourselves say, well, that's the end of that then. If you can't deliver on the buyout order's gone. Anyway, they got that. They got that, and so everything went through. But they were required to issue an application in paragraph 1, and of course this rather more engaged our attention because at this stage, for the money that we were providing, we were going to be deprived of the benefit of the purchase of 20% minority shareholding in the club, which we were quite interested in. So we opposed VBFA's application unsuccessfully. And we had to put evidence in by the 28th of May. So VBFA issued their application to vary the order at the end of the, which they obtained, their buyout order at the end of the 994 trial, and that's on page 41. And Mr. Cooper provided a further witness statement, a confidential witness statement on page 43, in which for the first time, at page 51, he set out what was the transaction which was proposed, although merely the principal terms of it. Page 51, paragraph 29. And this was the sale, bid one, which was the one to Mr. Sadler. And this is in fact the sale which ultimately went through. Then there may have been a draft sale agreement floating around, but we never saw that. So anyway, so this came in on the 22nd of May, which left us with a short period of time to put in our evidence, because the 22nd of May was a Wednesday, and that left us with Thursday, Friday, and then there was a weekend and a bank holiday. So 2 clear days before we had to put in Mr. Oyston's evidence on the 28th of May. And this, of course, was the first time that we knew about anything to do with the terms of what was being proposed. Mr. Oyston put in a witness statement on page 56, in which he concentrated on the position with VBFA's newly issued application. But he did, at paragraph 8 of it, on page 58, say that he understood the present applications to be limited to the issue of being able to include VBFA's shareholding in the potential sale as a matter of mechanics. And that's a perfectly fair thing to say, because that's what the application notice actually said. And that's what...
Sorry, this may be a detail. It says the present applications. It's not just referring to VBFA. There were 2 applications.
There were 2 applications by that stage.
And the first one was not limited in that way.
It was. Because if we look back at it, in tab 3, page 14...
It's sale of assets.
So...
may sell the assets set out at schedule to the attached draft order as part of one transaction.
Yes, but listing all those assets.
Yes, it did. Yes, that's right. But But when one reads that, it certainly doesn't say approval for the sale. What it suggests is that what is being sought is the ability to sell all of the assets as part of one transaction, critically including VBFA's shareholding, because that's what then appears in the draft order. And that is, as it were, cemented by what Mr. Cooper says at paragraph 29 of his witness statement in support at page 24, which is that we have to include VBFA's minority shareholding because nobody wants Mr. Oyston's minority shareholder once he's completed the buyout order. And it is for this reason that the receivers are making the application. Not for reasons of complete approval of the terms of the sale or anything like this. I mean, the terms of the sale hadn't even been set out at this point. They weren't set out for another 12 days after this.
And sorry, the page reference again.
That's page 24,
Thank
milady,
you.
paragraph 29. There had been no talk of approval by this stage.
But isn't this all one and the same in the sense that you've got to sell the VB shares with the rest to avoid Mr. Oyston becoming a minority shareholder?
Yes.
You're doing that because you're selling everything together, as you've already explained in your application notice at divider 3, page 14, and therefore it's known that you need to sweep up the VB shares in order that the whole package can be sold as a going concern. It's one and the same. It's all one issue.
Well, it is. But of course, the issue before the court now is whether the application, which was substantively made on the 5th of June, confers immunity on the receivers in relation to their tortious duty of care and negligence.
Yes.
And all we are saying in relation to this is it was hardly made clear from the outset of all of this. In fact, a fair reading would suggest quite the opposite. That they wanted cast iron approval for the terms of their sale, so that there could be no comeback in relation to it. What they were seeking to do was, as a matter of mechanics, to include somebody else's asset in the assets that they wanted to sell. It's for this reason that we're making the application. They wanted to achieve a composite sale as a matter of mechanics. They weren't saying anything at this point about the merits of the sale or some form of advance immunity from professional negligence.
No.
At some point, you're going to take us doubtless to what you say they did wrong. What's the thrust of the negligence claim they want to put now?
Well, I wasn't going to, because I've won that point below, and my learned friend doesn't have a...
Well, at some point, I'd like you to actually identify what is your core allegation as to what you say the receivers did wrong to breach their duty of care.
Well,
is it that they should have sold the assets separately?
Yes.
So, I mean, the question of should the assets be sold separately or together is something that was being raised, you say, as a matter of mechanics, but it's quite clearly on the table. That question, sell them separately or together, in front of the judge, in front of Mr. Justice Marcus Smith, and yet your current claim in negligence is founded upon an assertion that they should have sold the assets separately.
Well,
I'm not missing something.
No. But I do go back to the illuminating evidence in support of the application, which is at paragraph 29, which is the critical paragraph. On the basis of the position taken by prospective purchasers to date, i.e. that they don't want Mr. Oyston as a minority shareholder, it will not be possible to sell Denaxe's shares in DFC unless VBFA's shares are also included in the sale. It is for this reason that the receivers are making this application. It was the odd circumstances of having to include somebody else's assets in the package that they had to sell, and that was the purpose of this application.
I mean, we're going to skip out. I don't want to take you out of your course
No, of
because we're
course.
short on time, but let me just make just put something on the table. The receiver has a duty to realise the best price for all those interested in the assets subject to his control. Let me just put that as a general proposition
absolutely.
at the moment. I'm not getting specific about the origins of the duty, the nature of it, or otherwise. He's saying, I want to sell these assets together. If you thought that a better price could be obtained by selling the assets separately, surely it would be appropriate to have said so at the time.
Well, this brings into the way in which this application was made, and the opportunity that we had to deal with it. Because,
but that's not that's not a sort of detailed minutiae point. It's not getting down into the weeds. Well, it's a big picture point.
Well, it's a bit. It is in a way, my lord, because if you look towards the end of the supplementary bundle, we have what's been put in is the evidence about the alleged professional negligence, which was before his lordship, which
So which you mean Mr. Justice Fancourt,
yes,
Mr. Justice Marcus Smith,
before Mr. Justice Fancourt, which occupied the court for a day and a half, had a 2,000-page bundle and over 50 pages of witness statements, including evidence. And I mean, it's inconceivable that we could have shoehorned all of that into this period of time with what was being suggested. And in my submission, the reading that was an entirely fair one when you look at paragraph 29 of the judgment, that the only reason for the application was because of the inclusion of VBFA shares, and it was not sought to obtain some frankly inappropriate on the authorities a blanket immunity for a professional negligence claim.
But you're leaping a long way forwards, Mr. Collins, because you also have paragraph 2 of the witness statement, which is at page 17, which also says the applicant's application seeking an order that, and then it sets out all the assets that are to be sold.
Yes.
And there's no doubt that that's the proposed sale, that it's a bundle.
Yes. But if you are seeking sanction for a particular thing, you have to set out what you're seeking sanction for.
The proposed sale, isn't that what paragraph 2 says?
Well, it's seeking an order that the receivers may sell, and then the last words are quite important, together as part of one transaction.
Yes.
Yes.
And that fits in with the application notice, which says we want to sell the assets.
But you have to identify what you're seeking sanction in relation to. And when we come to the authorities in insolvency, you have to set out what you want sanction in relation thereto. You can't just say something vague. But that does not carry with it in our submission, and certainly should not carry with it, a complete immunity from professional negligence in relation to the sale, because approval is different from sanction.
Yeah, but you're running ahead of yourself. What we're looking at the moment is just the bare bones of what Mr. Oyston knew about or could have discerned. And we've looked at the application and we've looked at these paragraphs in the witness statement. I think
we have,
should move on.
And we were on page 58, being Mr. Oyston's reservation of rights as to marketing and value, because he was concentrating on the mechanics and the new application that had been issued by VBFA. Now, what Stevenson Harwood wrote on the 29th of May, on page 59.
Just out of interest, Mr. Oyston opposed the application to vary the buyout order.
Yes.
On the basis of what? That the shares shouldn't be.
Well, on the basis that at the end of the trial there was a final order that if he came up with £30-odd million, he would buy 20% of the club, and that was just changed by the learned judge. And it was a final order at the end of the weeks of a 994 trial. So yes, we did oppose it because we did want something for our money. It wasn't a derivative claim or something like that, which was just a money claim. It was that 994 buyout.
Yeah,
and we were getting nothing for our money at that point.
Well, Mr. Oyston was required to pay.
Yes.
To get the 20%.
Correct.
He hadn't paid.
Correct. Not yet. No.
Well,
that's what they were seeking to do by this. They were seeking to enforce the money judgment.
Yes, but sorry, he was in default of the money judgment, wasn't he?
He had not satisfied the money judgment. That's right. He has now satisfied it, but he hasn't got his 20% because of this variation.
Okay, but so he comes to court saying, "Well, I know I haven't actually satisfied the monetary judgment, and a receiver has been appointed to." I'll use the expression by way of equitable execution because it's a convenient shorthand that everybody uses, to enforce the judgment which has been obtained against me.
Yep.
On what basis? At that stage, he's got really no grounds to say, has he? Well, you shouldn't engage in this other composite transaction. Because in a sense, that's the only way that the successful creditor is going to get paid.
You are actually, with respect, Lord, you touch upon another point, and that is that Mr. Oyston's locus in relation to all of this was rather difficult. Even though he was given the opportunity by the learned judge to turn up, it's entirely unclear what his locus to do so was, or to say anything, because it wasn't his assets that were being sold. It was Denaxe's assets, and he wasn't in control of Denaxe. He has the only authority that he would have is in order to challenge the receivership itself, which he was not doing. Even if he had sought to challenge the sale or prevent the sale, if he had any locus to do so, which I don't think he did, there would have been an injunction which would have required a cross undertaking, which he couldn't possibly give because he was a judgment debtor. He had no objection to public trustee and Cooper approval of a breach of fiduciary duty because we weren't and aren't concerned about a breach of fiduciary duty. We had no concern about breach of an equitable duty of skill and care because there isn't one in these circumstances. It's a tortious duty of skill and care which the receivers owe, and that's how the matter went on.
Sorry, I don't want to get bogged down, and I will shut up because I appreciate moving for a shorter time. But so did his shares in Blackpool Football Club Properties Limited were going to be sold?
No, they weren't. No, his shares were not being sold. The only things that were being sold were Denaxe's shares in Blackpool, in the club. Okay. And the hotel and Denaxe's assets.
We're talking about his economic interest through Denaxe because he was a controlling shareholder.
Yes, but an economic interest doesn't give you necessarily locus.
Yes, but whether he had locus or not, the judge actually did give him the opportunity.
Yes, he gave him the opportunity. Yeah. Well, and of course, the most important thing that he did have locus in relation to was an application that was made by VBFA to upset the order at the trial, which was against Mr. Oyston, the buyout order, because he would have otherwise acquired, once the money had been provided, a 20% minority shareholding in the club. So he certainly had an interest in that. And that's what the primary focus of his arguments at the hearing was. Now, Stevenson Harwood, on page 59, wrote after Mr. Oyston's witness statement, and this gave some 3 clear days before the hearing. At paragraph 3 of their letter, saying, "We note the reservation of rights in relation to the marketing and valuation of the proposed sale. For the avoidance of doubt, the receivers will be requesting the court to direct them to complete a sale of the assets listed in the application on the terms and in the manner set out in our client's evidence." And that was the witness statement of the 22nd of May of Mr. Cooper. If your client objects, it's incumbent on him to explain the basis of such objection. Now, this, of course, was getting much closer to a complete immunity type application, but this was some 3 clear days before the hearing, and it was simply not possible to shoehorn into this, or any, frankly, much longer period, the enormous industry that went in to the application before Mr. Justice Fancourt. My learned friend and I both had skeleton arguments over 30 pages in relation to all of this, and in relation to expert reports and goodness knows what else. It was not possible simply not possible to have.
So was there a response to that letter?
No. And Mr. Cooper then puts in a third witness statement with more details on page 70.
So nobody took issue with the first sentence of the second paragraph of the letter.
The first sentence of the second paragraph says that Mr. Wilson appears to accept the necessity of selling. We certainly did, because we opposed that root and branch. We understood why people might not want Mr. Oyston as a minority shareholder, but that's not an answer as to why the final order, at least in his favour to the extent of acquiring a 20% under his buyout order, should be upset. And it was pretty obvious, because we opposed it and sought permission to appeal unsuccessfully, that we did oppose VBSA's application root and branch. Okay. And that is what appears from my skeleton argument at page 77.
But we were at page 70, the further witness statement of Mr. Cooper.
Yes, well, that just gives a little bit more information about the proposed sale. Although again, even that on page yes, even that on page 75, in his conclusion, rather concentrated on the fact of the sale of the assets together, by which he always meant including VBFA's shares. That was the point in our submission to this whole thing from the outset. Now, his lordship then dealt with the matter, and his judgment is at tab 15. And at the hearing on the 5th of June, and at page 91, paragraph 41. Counsel for the receivers sought to draw an analogy between receivers and trustees and administrators, and then it went to my Lord Justice Snowden's judgment in Nortel, and he considered the matter to be right and the analogy to be an apt one. And I'll come to MF Global and Nortel in a minute, if I may. Paragraph 46.
Is there something wrong with the first sentence, paragraph 44, by the way? Is there a word not missing?
Receivers by way of extra relationship do, unlike trustees, have the benefit of specific provisions.
It's do not, isn't it?
They do not, but they did in this case, because they are only creatures of the court order.
I don't think anything turns on it,
no.
But it is actually, it should say do not.
Unless he's referring to the typical order.
Well, I think what he's saying is they don't have the benefit of specific provisions explicitly conferring on the right to seek directions, because presumably there wasn't anything explicit anywhere, is there?
There is, there's nothing explicit in the law, because they're not creatures of statute, unlike trustees and administrators, or at least they're not. Yep. They're not creatures of statute like administrators, and they don't have the benefit of the statute like trustees.
But they're officers. They are officers of the court.
They are officers of the court. They're fiduciaries.
Implicitly,
and in the order, yes, implicitly as officers of the court, they'd be able to apply to the court for directions. But they were given specific power in the receivership order, I think, to apply to the court for directions.
This is paragraph 16.
Yes, page 7.
Yeah. Anyway, sorry.
But yes,
other than that, I just wondered whether that was...
No, with respect, my lord, you're quite right. They do not, as of right, unless it's conferred upon them, or at least, unlike trustees and administrators, they don't have a written right, but they do as officers of the court, usually in an order.
Just the grammar of the sentence.
No, that's right. Paragraph 46, Mr. Collins in his submissions laid great stress on the fact that, at least in the case of trustees and administrators, a degree of immunity follows if the court sanctions a particular transaction. It's not necessary for me to decide it. If, as a result, and then at the end, a degree of immunity follows, then so be it. I have no issue with the degree of immunity which follows from the orthodox application of public trustee and Cooper in these circumstances, and that is that I may not complain about a breach of fiduciary duty on the part of the receivers, and I may not seek to impeach the transaction. That's the purpose of.
So, just to be obviously very clear about this, do you accept that following a public trustee and Cooper type application by a trustee,
Yes.
simpliciter, that nobody could seek to say that the trustee had sold the assets at an undervalue?
Yes, I do, and I think it would come as a surprise and a shock to trust practitioners if a properly made public trustee and Cooper application on full information, i.e. one that was not itself capable of being vitiated through want of full and frank or some sort of semi-Wensbury type attack, did not confer complete immunity on a trustee, both in relation
I'm not sure about that, as a matter of fact, but that's you are conceding that point.
Yes, because
And you say, I'm sorry, before you go on to something else, complete immunity.
complete immunity in relation to breach of fiduciary duty, breach of trust, and breach of the equitable duty of skill and care. I mean, one is getting into quite a difficult terminology here, because the cases that there are, and the authorities, and Lewin all talks about a breach of fiduciary duty or a breach of trust. But Lewin later on, and cases like Mothew, talk about the equitable duty of skill and care that's owed by trustees. And as a matter of terminology, I don't think that can be shoehorned in quite the same way into certainly it can't be shoehorned into a breach of fiduciary duty. Well, Justice Miller would be very cross with us if we
Speaking entirely for myself, and you're going to come on to this, the focus on the source of the duty, whether it's equitable or statute or common law, may be of less interest than the nature, the precise nature of the application, in the sense that if the application does not seek to bless a sale at a particular value, I would be surprised if a trustee was.
Well, they always do.
Well,
I mean,
but as a matter of principle, when we come to look at public trustee and Cooper and the cases that have followed it and what it is said is being done, I'm not entirely sure, speaking for myself, that they do go to the question of how much are you getting for this asset.
well, I think it all rather depends upon how the application is made.
In which case, that may be more important than focusing on the source of the duty.
Well, I mean, if you look back at some of the cases in trust, some of the celebrated cases in trust law, I mean, like Bartlett and Barclays Bank, for example, that was really the equitable duty of skill and care. But a case like Nestle and NatWest was much more about a breach of trust, because that was a failure of something under the trustee.
Yeah, I just wanted to
and certainly, so far as, I mean, the way in which this is done in the trust field is these applications usually turn into leviathans, and absolutely everything is put before the court, expert evidence on the value and all the rest of it, so that the trustees get blanket immunity for breach of fiduciary duty, which might be because of a conflict or something like that, breach of the equitable duty of skill and care in relation to selling it properly and taking professional advice and not failing to value part of the field which has got planning permission or whatever it might be, and then you get.
Now, might that be? And sorry, we are skipping ahead.
Yeah.
Tell me to shut up and take your own course, but I just put the question there. Might that be appropriate in the circumstance where you had a non-professional trustee of, say, a family trust?
Yes.
And where there was time to consider the administration with some leisure of the trust, say a family trust,
Yes.
over a piece of property of the estate held in the family for generations.
Yes.
It's not the same where you have a professional
Well,
office holder in
it is
insolvency where something
Oh,
needs
it's
to
not
happen
certainly not
fast.
No, absolutely, it's certainly not the same in relation to an insolvency office holder, or we would say somebody who holds one has to be careful about the term office holder, because that's a term of art under the Act. But somebody who holds office, such as a sequestrator or a receiver, who is put in specifically to do a job as a well-paid professional, and sometimes in very rapid circumstances. Yeah. That's exactly right. And of the whole, I'm so sorry, Milady.
No.
And the whole thrust of this jurisdiction in relation to holders of office or office holders, professionals, is that you do not come to court to get blessings, because otherwise we'd frankly be inundated. And why leave it to them? If you can come to court and get advance blessing for tortious duties of care, I dare say the revenue bar might be quite interested in that and come down and get some advance declarations so that they're not all found to be in goodness knows what trouble in many years' time. And the floodgates open. And that's just not what happens. Trusteeship is entirely different. And that's what public trustee in Cooper says. Now, if it goes as far in these Leviathan applications as the trustee getting complete immunity, not only in relation to the fact of the sale, but the terms of the sale, so be it. That's what I've got no quibble with that, because that's not this case.
So when you say in paragraph 4.7 of your skeleton, you make the concession that you've made orally. I describe it as a concession. You make the statement which you describe.
Yes.
You're saying that would be if the trustee had sought such blessing, i.e.
Yes.
if the trustee had actually come to the court and
Yes.
said,
yes,
I want to sell for X, this is the professional advice that I've received.
told the beneficiaries, they don't mind.
etc. But it's not automatic if the trustee, for example, doesn't come and put that material before the court.
No,
It simply says, I want you to check, court. I know what I want to do,
Yes.
but I want you to check that I've taken into account all the relevant factors. I'm not acting in a position of conflict. I'm acting rationally.
Yes. Yes, my lord. Absolutely. Because, for example...
In which case it wouldn't follow.
That's exactly right. If a trustee makes a more limited application, for example, because they're concerned about a conflict or something of that sort, they might want to come down to court for a blessing so that there's not a breach of trust or a breach of fiduciary duty, and they don't trouble the court about the terms of the sale because they're perfectly happy with the propriety of that. Normally, they throw absolutely everything.
Why in a trust case shouldn't the court also forget insolvency for a second where it's more acute? Why in a trustee case shouldn't the judge be entitled to turn around to the trustee? Let's even assume it's a family trustee and say, well, I can deal with as a judge the questions of conflict, rationality and power, because those are legal issues.
Yes.
But when it comes to actually selling the thing, you've got professional advisors, they've got professional indemnity policies, they're expert. I'm not. You know, you take your own risk.
Well, they certainly could, and I'm bound to observe this is the first time that this jurisdiction has been considered by a higher court than first instance in relation to this. But except
Well, I'm just thinking of Cotton and Brudenell,
I was just about to say that,
where the real question was about the mechanics of the sale.
Yes.
And there was endless evidence
There was.
from endless experts about how and what and who and how to sell.
Yes.
And the decision of the Court of Appeal in that case was it's not for us to winnow out all of this expert evidence. It's been taken, and all the other aspects of the public trustee and Cooper application are satisfied.
Yes.
And so, if it turns out that the expert evidence was wrong, somebody can sue them. But
Well, milady, with respect, that's a very good point. Because of course, the place where tortious duties really come in is not in relation to trustees because they do not owe tortious duties of care. They only owe equitable duties. But of course, it's in relation to third parties, which is, the sort of White and Jones situation. In fact, that's exactly right, and that's where tortious duties often come in relation to actions against professionals. can I just pick up something that my Lord Justice Snowden has said as well? And that is what a trustee may be asking to do. I gave the example of a conflict or a perceived conflict and wanting that to go before the court with the beneficiary's ability to say something and for them to get a blessing so that there can be no upsetting of the transaction or breach of fiduciary duty claim thereafter. Your Lordship raised the point about power, fraud on the power, and of course that's also very important because there may be an issue under the trust deed as to the terms of the power or the purpose for which the power was conferred, which is the fraud on the power point. A trustee may perfectly well, in certain circumstances, because these things aren't often brilliantly drawn, and any number of circumstances can arise in any number of situations. The trustees may want a blessing purely in relation to the power, rather than the exercise of that power in certain circumstances. I.e., do I have the power of sale? Can I make this sale without getting into the terms of the sale, which are entirely different? And there's one important bit in the judgment below where his Lordship just enlarges those two things completely, and basically says that my claim for prof neg is actually essentially a fraud on the power, and that's of course just completely wrong. It's not about the exercise of the power of sale, which they've got. It's about the negligent exercise of the power of sale.
Mr. Collins, we are short of time, but perhaps we can just summarise. I don't think there is anything between any of us about the fact that if we're talking about trustees, what they get is dependent partly on what they ask for, and what they ask for depends on their particular circumstances, and the court will or will not bless what it is that they've asked, and that might descend to sale at a price, for example, the Cotton and Brutonal Bruce situation, or it may not. It depends what they ask for. And if they ask for it and it is approved, then in all respects, in fact, they are safeguarded.
Yes.
Put it that way.
Yes.
Because all of their various duties allied.
And can I?
But that is a mile away, you say, from the situation we're in. So
yes.
let's move on.
Milady, that was something I was just about to pick up again from what my Lord Justice Snowden said, because he said a little earlier in the debate, is there essentially made the point with which I respectfully agree about the difference between a family trustee and a licensed insolvency practitioner. And there's all the difference in the world, not only between the appointment and what may need to be done and the speed and so on and so forth, but there's also all the difference in the world between the actual person. Now, even in the case, so it's not at all surprising that in the context of a family trust where an aunt might have been appointed to some valuable property, that this poor lady who's not remunerated and not a professional ought to be able to go to court and get some comfort from a decision that she's taking bona fide on the basis of having taken expert advice and so on and so forth. And if anybody gets it wrong, it's the experts, and they can be sued, not her.
But Mr. Collins, it isn't such a clear-cut situation as that, is it? For example, a very large pension scheme with billions of pounds of deficit will probably ought to have professional trustees who are very experienced in this area. So it's not a cosy aunt with her shawl wrapped around her on one side and these wicked office holders on the other.
No, milady. I was going to say, of course, that it's not always in a family context, but quite often is. The trustees in Savanac Forest wasn't a professional trust company, but where you do have a professional trust company, they're at liberty, and usually that's in relation to the much more substantial matters. You get these public trustee and Cooper applications frequently in Bahamas and Bermuda and so on in relation to trusts worth billions, because these are very significant decisions being made, possibly even investment decisions, where everything is put before the court because there's so much money involved that really they want blanket immunity, and that's all well and good. That's getting much closer to the office holder situation. I agree.
So let's go to the office holders and where you are.
Let's go to the office holders. Well, I don't really need to say much more than I have already said in my skeleton argument in relation to that, because at paragraph 6.7, which is on
It's 212.
page 212 of the core bundle, I refer to what I say is the settled practice in relation to office holders, or indeed holders of office, that the court simply doesn't get involved in it. I start with a case called Montin. I go through Osmosis, T&D Industries, and which was in fact cited in MF Global and also by my Lord Justice Snowden in Longmead, and I think, I'm not sure about Nortel, but we'll look at that in a moment. There's one other earlier case than this called MTI Trading, where Mr. Justice Newberger, as he then was, says that one of the reasons that you don't have these sorts of things is that these sorts of applications, because it rather demonstrates that the court would rather demonstrate the court has no confidence in its office holders who've been appointed for a specific thing, usually in relation to realisation or management of assets. The reference to, if it's of any interest, the reference to MTI Trading is, it's a slightly earlier case than...
It's slightly weird to sort of give the court quotes, the sort of artificial, to assume the court can think about things, have confidence. I mean, somebody's just appointed and comes before a judge. I mean, the real points, I think, are the ones you've already made in the skeleton, which is that if you have insolvency office holders, they are professionals, they're remunerated as such, and
yes,
they're paid to take commercial decisions.
That's right.
And the point is, you don't generally, let's just use that word for a moment, expect professional people appointed for their expertise, remunerated for their commercial nous, to come to the court and ask some judge who's not appointed for either of those two reasons, but is there to resolve legal issues on the whole,
absolutely,
to take over and make commercial decisions. And that's what Mr. Justice Newberger, as he then was,
yes,
was talking about when he in TD Industries.
Well, and that's what, and indeed in Montin, and what Mr. Justice Reimer said in Osmosis, and indeed with respect to what your Lordship said in Longmead, because all your Lordship said in Longmead was that in those very rather exceptional circumstances, the liquidators were entitled, I think the words were to a measure of your Lordship's exact words in Longmead.
Well, don't worry about my exact words in any of these. I should make it perfectly clear, nobody should worry about my exact words in any of these cases. You have I'm sure neither of you will pull your punches if you think I said something I shouldn't.
You weren't. You certainly weren't giving them carte blanche. You were giving them a measure of assistance in relation to an indication, and making it quite clear that the decision was there.
Yeah, but just make it clear. I mean, if you think I said something I shouldn't have said in any of these first instance decisions, then don't get hung up on that.
Well, perhaps with that invitation ringing in one's ears, perhaps one should go to Nortel in a moment. But before we do, could I take your Lordship and your Ladyships to MF Global? I should say at this point that I'm going to skip over the following point, and that is that it is absolutely plain that that these receivers owed a tortious duty of care. My learned friend has a tortuous argument trying to equate them with the receivers appointed by mortgagees, but that's a totally different situation. In the case on all of this is IRC and Hoogstraten in the Court of Appeal, Lord Justice Dillon, which is about sequestrators, but he equates sequestrators and receivers, and he's not talking about receivers appointed by a debenture holder or a mortgagee. He's talking about Section 37 receivers of this sort. And later on, he does so specifically in relation to the NUM, equate the two. an IRC and Hoogstraten has been applied twice in this case at the behest of the receivers. First on their discharge in December, when we had the order that any prof neg claim should be brought within a certain period of time, otherwise they would get complete immunity. That's the December discharge order. And secondly, by my Lord Justice Snowden, when Millennium friend Mr. Moynihan embarked upon his first challenge to my Part 7 prof neg claim, which was that I needed the permission of the court to bring it. Millennium friend at that stage prayed in aid IRC and Hoogstraten. Your Lordship's judgment is in the supplementary bundle. That was a hearing we had remotely in Manchester when Your Lordship was Vice-Chancellor. And Your Lordship determined that we did not need permission. And Your Lordship cited quite extensively from Hoogstraten, including the passages which deal with duty of care and equating sequestrators with administrators. But if I could turn straight on to MF Global and then Nortel, and these are in the second file of authorities at tab 19. And I do just want to go to MF Global first, if I may, because it's quite illuminating in that it was a hybrid application. And that's important in my submission, because we see from the impressive representation on the second page of the report that both the trustee and the administrators were represented, and we see that.
It's just above. It's in the head note, just above.
Yes, it is. And we see from page.
There's a sentence just above the head note of E, which makes your point, isn't it?
Yes, it is.
The bank held funds in two different capacities, so that clients could be both beneficiaries and creditors or debtors.
That's right. And if we look at page 1161 of the report, which is page 385 of the bundle, at paragraph 24, there is reference to section 15 of the Trustee Act, and that's, of course, the application by the trustee of the Client Money Trust. And that then brings in Public Trustee and Cooper on the next page, in an orthodox situation, because this is in the context of the trustee making an application. And then, when His Lordship comes to the position of the administrators, he does so at the bottom of page 1164 of the report, page 388 of the bundle. And this is a passage that was cited by Your Lordship in Nortel. And this repeats the T&D Industries point, but importantly in my submission, over the page at 1165b, the present application is made by the administrators in their capacity as such, for the same reasons as the application made by the trustee, in particular because the administrators are involved on both sides. So there is a quite defined issue of conflict and breach of fiduciary duty, which needs to be sanctioned by the court, so that the compromise cannot be impeached. Because if you could start undoing these compromises, it would lead to all sorts of problems. Of course, and that's the purpose of this. It's to obtain certainty. It is not to obtain blanket immunity if you've negligently mucked up the compromise. Breach of fiduciary duty, yes. No conflict of duty or anything like that. Not impeach the transaction, but it leaves the issue in our submission of prof neg at large. Now, what we then do is go to Nortel at tab 22, and Nortel was not a hybrid. It was it was just office holders in the context of a very complicated group. And Your Lordship deals with the law on page 601, and there was a conflict administrator here, but one can see again why the administrators in a group such as this would want some assurance that the whole thing could not be undone, because if you were able to go back and impeach the entire transaction, it could lead to complete chaos. What your lordship does is your lordship cites from MF Global at paragraph 45, including the passage I just took you to, although it runs out, the citation runs out before the reference to administrators being on both sides. So it runs out before the conflict point.
Yeah, well, I was aware of it.
Of course, my lord.
I said there at the start of paragraph 45.
Absolutely.
That the assets were held to be on its own account and on trust for its clients.
Yes, I rather meant though the conflict point which was highlighted by in that passage in MF Global. Because the administrators are involved on both sides, which in fact is the same point, trustee and administrator. Yes.
I mean, it happens every time you have a company which acts as a trustee.
Yes.
It's because, to the extent you, as it were, favour the beneficiaries in relation to assets held on trust.
Yes.
You remove assets from the general estate, which are distributed amongst the unsecured creditors and bodies.
Absolutely.
So there's an obvious conflict between those two groups of people.
Yes.
Who the administrators have to serve.
Yes, quite so. Now, the interesting thing about Nortel, though, is that it not being a hybrid case, it nevertheless applied public trustee and Cooper in purely an insolvency context. And with respect, I take no issue with that. What your lordship then does at paragraph 50 on page 603, having been through public trustee and Cooper and how it is dealt with in Lewing, your lordship says, in these respects, the approach of the court will mirror the attitude which the court would take to a subsequent challenge to the decision by a creditor, e.g. Longmead. Now, pausing there, what that is about is a challenge to the administrator's decision.
Yeah, wait a minute. I think you've got to go back in my own defence here. Having invited you to have a pop, I'll do a little bit of defending. In paragraph 49.
Yes, my lord.
I mean, I summarise what I took from the authorities, public trustee in Cooper and MF Global, just between D and D.
Yes.
The court should be concerned to see the proposed exercises within the administrator's power that the administrator genuinely holds the view that what he proposes will be for the benefit of the company and its creditors, and that he's acting rationally and without being affected by a conflict of interest in reaching the view.
Yes.
But the court shouldn't withhold its approval merely because it wouldn't itself have exercised that power in the way proposed. Now, just to be clear what was going on here, this was an enormous worldwide settlement between conflicted different estates of the worldwide Nortel group who were in conflict.
Yes.
And there was a conflict here because you had an American arm, you had a Canadian arm, and you had a Europe and the Middle East arm. And the question was, how did the assets in the lockbox, which they'd achieved by a sale of the global group, how were they divided up between the rival claims of those three groupings?
Yes.
And there was, in a sense, there's an obvious conflict between, it's a bigger conflict, as it were, in which the administrators are playing a role on behalf of the UK, European and Middle East company.
Yes, my lord.
I mean, one thing that was happening here, just again to put it clearly in context, I mean, if you actually look back at the head note, this was a decision given in the space of 4 days, I think, possibly over a weekend. But anyway, this was a fast decision.
Yes.
And had to be because although it had been going on for yonks, there was a lot of impetus to get a settlement achieved. But nobody was suggesting that the actual numbers, i.e. how the estate was divvied up, was something that I had to concern myself about. In other words, that was the administrators who'd negotiated long and hard.
Absolutely.
So, I just want to be clear about what we're actually dealing with.
I'm rather hoping that that the next point that I'm going to put will meet with approval. because his lordship below took it in a different way. Our respectful submission is that your lordship was not granting by this judgment immunity for any professional negligence in and about the compromise. So that, for example, if, I don't know, the English administrator had made a total muck-up in relation to the compromise and had vastly underestimated the value of an asset which he compromised for little or nothing, that the creditors couldn't complain about Prof Neg in relation to that because of this judgment.
Mr. Collins, doesn't it all turn on what you ask for? We're back to the same question as if it were trustees. It depends on what you ask for in the particular case, and therefore what's before the court, and the scope of what the court determines is appropriate to bite on. And in this case, before Mr. Justice Marcus Smith, the question was, should all of these assets be sold in one transaction? And the answer was yes. And that has not been appealed.
No. Yes, but I have no objection to all the assets being sold as part of one transaction. Because
you have no objection to that, but I thought you did. I thought that's what you did.
No, I have no objection to them. I have no objection to those mechanics. And the critical aspect of those mechanics is that the receiver was not asking for just all his assets to be sold as part of one transaction. He was asking for somebody else's assets to be included in that, and that was the whole reason. That's the point that I've already made.
Yeah, and that's your angle point. But I thought that in relation to the deal that you'd accepted, that what you said was the mischief, and I think you explained that to my Lord Justice Snowden, was that they were all sold together rather than separately.
Well, that's the Prof Neg aspect of it, yes. That's
yes.
where, in fact, that's the Prof Neg is not entirely limited to that.
So you're saying that the Prof Neg, I'm sorry to interrupt you.
No,
the Prof Neg exists separately, and although there was a sanction of the sale of the assets as a whole, as one transaction, and we're avoiding the VB issue,
yes.
Nevertheless, because the tortious duty was not, the box was not ticked and could not be ticked in relation to that nevertheless always enabled you, despite the sanction of the court, to say, but actually they should have been sold separately.
Yes.
So that means that in relation to an office holder of this kind, seeking the kind of relief that was sought is purposeless.
Yes, and there are a couple of points that I need to pick up from your ladyship's references there. I mean, the actual order that was made after the 5th of June was that the applicants and VBFA may sell to Mr. Sadler the assets set out in the schedule to this order together as part of one transaction on the terms in the confidential statement, which is just identifying actually what the transaction was. The whole thrust of that paragraph is permissive and a sanction in relation to the mechanics in our submission, and not anything to do with the merits.
Sorry, which page was that at?
This is on page 135 of the supplementary bundle, paragraph 1 of the order that was in fact made. And that's why my learned friend and I have indulged in a bit of an argument over what he would say is just pure semantics, and I say is rather more important than that, is the difference between sanction and approval. And it's made quite clear in the insolvency authorities, including by Mr. Justice Neuberger, and we've highlighted it, I think it's in the first case, Montin, that there is a difference between sanction and approval, because sanction is about the power, and approval is something completely different. That's granting complete approval to the terms of the transaction. Whereas, and you can see this difference coming about in the authorities that we've cited, which are, including T&D Industries, because it all arose in the context of administration, where there was uncertainty and a bit of a wrangle as to whether you could sell assets prior to what was then the Section 23 meeting. It was thought that you did not have the power to sell, but you could apply to the court for that to be granted that power and sanction. And that's what was happening in those cases. It was all about power. And those cases then specifically said, but we're not saying anything about the merits of the sale. We're just giving you the power to do it because you don't otherwise have it. Totally orthodox sort of application of akin to public trustee and Cooper. And this is why we say, when one comes to Nortel, that what my Lord Justice Snowden was doing was as he highlighted paragraph 49, and in fact, just between D and E, your Lordship says why most of the same consideration should not apply. Not all of them. And that is in relation to conflict, power, fraud on the power, all of those sorts of issues of proper purpose and not the merits. And that's why in paragraph 50, it is, your Lordship then deals with it in the way that you do, because it's not saying, and of course this gives the administrator absolute carte blanche, nobody can complain about this forevermore. What your Lordship actually says, this mirrors the attitude which the court would take to a subsequent challenge to the decision. And that challenging a decision is impeaching a decision, impeaching the compromise, not saying anything about Prof Neg concerning the compromise, no. It is to provide some certainty without going any further, having regard to the fact that its approval will prevent subsequent challenge, and by challenge doesn't mean challenge on Prof Neg basis, it means challenge to the actual transaction. The court will require the administration to put all relevant
But how does this help? Because as my Lord Justice Snowden said, the background to this was that there'd been inevitably endless and very complex, lengthy negotiations around the world and different groups of creditors, different interests, etc. And the court was not being asked to get its magnifying glass out in relation to that. That was not what was before the court.
Exactly.
So to come back to what I said before, it depends what you ask the court to do.
Well, what they were asking for here was, well, they were certainly not asking for complete exoneration for any Prof Neg, because that would be it's quite inappropriate on the authorities and would be grossly inappropriate in a case such as this.
And we're at a higher level.
We're at a much higher level in relation to exactly those sorts of considerations of exercise of power, not the actual power, not the if you've exercised the power of sale, whether you've done so negligence, the actual exercise per se, and not being able to impeach the transaction. And that's, with respect, an entirely orthodox and appropriate application of public trustee and Cooper in the insolvency context. It absolves the administrators of breach of fiduciary duty, including things like conflict and and abuse of power or proper purpose or anything like that at the higher level. It ensures certainty for the transaction because it cannot hereafter be challenged, impeached. But it says nothing if something emerges that the administrator in this case has made a total muck-up, professionally negligent, and given away a valuable asset as part of a compromise in a way that is professionally negligent and for which he ought to compensate the persons to whom he owes the duties. That's the point. And your ladyship says about we didn't appeal Mr. Justice Marcus Smith's order. Well, I didn't have anything to appeal because his lordship did not decide the point about immunity. That's essentially what's being decided hereafter in our submission by the learned judge wrongly, saying that public trustee and Cooper jurisdiction that was being applied as it's being applied in Nortel extend to the tortious duty of care, which it does not in our submission. And so there was nothing to appeal on that because he hadn't decided it. And it would have been a very difficult matter to appeal in any event because they weren't my assets being sold, they were Denaxe's. But I am Denaxe now, and I'm complaining that they were sold at an undervalue. We've got the company back, having discharged the judgment. We've been able to look into it fully and properly. We brought a Part 7 claim. it has received a judicial approbation to the extent that Learned Friends Part 24 was not permitted, and it should otherwise go to trial. And the whole issue is whether what happened on the 5th of June provided immunity from the tortious duty of care and to professional negligence. And in my submission, it plainly did not. Now, can I just highlight a couple of points from the judgment below? Which is in the core bundle at tab 1. On page 12 at paragraph 56, it is likely that Mr. Justice Millis and the editors of Lill refer to immunity from allegations of breach of trust because they were addressing the case of trustees applying for direction in relation to a transaction. They weren't distinguishing a claim for breach of trust from other types of claim. Applying the principles from trust cases by analogy, one would expect that the immunity conferred on the administrators in Nortel, as held by Mr. Justice Snowden, would not be, or not only be, against a claim for breach of trust, but extend to liability for the types of claim that might otherwise be brought against them, whether under statute, common law, or in equity, for causing the company in administration to enter into the proved transaction. So his lordship is, my Lord Justice Snowden is in a better position to say what was happening there than Mr. Justice Fancourt. But what...
I'm not sure I did hold that, did I?
You did not. In our submission, you did not.
I might have done. I mean, it's possible,
no,
but I can't remember being asked to consider question in the same way that Mr. Justice Marcus Smith didn't. I don't think anybody actually argued the extent of the immunity that I was conferring in front of me.
No, but it was approached in an entirely orthodox way.
Yeah.
It was approached on a public trustee and Cooper basis, and your lordship dealt with it in paragraphs 49 and 50 of Nortel in the way that we have at my Lady Justice Asplin's higher level.
But the great benefit of sitting here now is that, in a sense, it doesn't matter what I did or said. You actually can say what should have been done and said. And that, in a sense, that's the real invitation to you. It's not so much to focus on what I did say or then. It's you say, as I understand it, if you have a claim or an application such as Nortel, where you're asked to apply the trust cases by analogy.
Yes.
If the application doesn't, even if it's saying we want to enter into this particular compromise, because that's what they did say.
Yes.
There was only one compromise on the table, and they wanted to.
Yes. They identified
authority to enter into it, not anything else. If they say we don't want you to look, Judge, because into the minutiae, get down into the how we got there, the negotiations, because we can't, it's just not feasible. Then you say, well, you don't get
absolutely
immunity from it.
And I go further, and so the application of public trustee and Cooper in the insolvency or holder of office or office holder context is all well and good so far as it goes, but it can't be taken too far, which is what happens in this case. Your lordship, with respect, quite appropriately, exercised that jurisdiction in the context of insolvency and was not asked and did not seek to go into the minutiae. You dealt with it in paragraphs 49 and 50 at the higher level in relation to vires and ultimately an inability to challenge the decision, to challenge the transaction. But you did not get into the underlying merits of whether an administrator might have been professionally negligent in actually entering into this thing, which is a completely separate matter. And had your lordship been asked to do so, which you were not, on the authorities, clear authorities in insolvency, T&D and all the rest of it, your lordship would have declined and said, no, it's a matter for you. Now, in public trustee and Cooper, depending on how the application is made, it might actually go further. It might go beyond vires into equitable duties of skill and care, depending on how much bump is put before the court in these leviathans. I mean, one can't conceive after this after Savernake Forest having gone up to the Court of Appeal, that that Lord Cardigan or any of the Bruce family could complain about what actually happened, because it was exhaustively gone through. But that's the trustee context, and we just don't do that in insolvency, in my submission, because it's completely inappropriate. And what his lordship is saying in paragraph 56 is that that's exactly what you can get in insolvency. You go into the absolute merits of the whole thing, which you did in Nortel, which you didn't, and therefore you get blanket immunity, including for tortious duties of care. And one of the problems, of course, is, and perhaps he wasn't given as much assistance as he should have been, is a proper distinction wasn't drawn between equitable duties of skill and care and tortious duties, and the position of office holders being quite different from that of trustees. So paragraph 56 is at fault. On page 15 of the bundle, the next paragraph with which we take particular issue is paragraph 78. Although the principle of immunity derives from cases where the court gave directions to trustees, where a claim might otherwise be brought for breach of trust, I don't consider that immunity in office holder or trustee cases is limited to claims for breach of fiduciary duty. There's no suggestion in the authorities that a trustee is only immune to such a claim and not to a claim for breach of a common law or statutory duty of care in making a decision to invest or sell. Well, that is all right so far as trustees go, because I have accepted, depending on how the application is put, that a public trustee in Cooper application may provide absolute complete immunity for a breach of fiduciary duty, breach of trust, and breach of the equitable duty of care. But that is no basis at all for just extending it into the insolvency context, contrary to all the authorities in that context. And at paragraph 83, we have his lordship again suggesting what might have been in my Lord Justice Snowden's mind in Nortel. I cannot imagine that Mr. Justice Snowden believed that immunity for the Nortel administrators would be limited to claims that might be brought against them for breach of fiduciary duty, so that if the company or creditors alleged that the compromise authorised by the court was a negligent breach of their duty to obtain the best price available, see Charnley Davis, main case on admin, Prof Neg, rather than a breach of the fiduciary obligation not to prefer their own interests, there would be no immunity as a result of the sanction of the compromise. Mr. Justice Snowden referred to the consequence of approval being that it would prevent subsequent challenge in general terms. In my submission, that's all completely wrong. Because when you talk about challenge, you're talking about a challenge to the decision, as your lordship plainly was in paragraph 50 of Nortel, a challenge at which all goes to vires, it all goes to impeaching decisions and the actual transactions. In my submission, your lordship absolutely was not conferring, was not being asked to, and if you had been asked, would have declined, not conferring immunity for negligent breach of their duty to obtain the best price available.
Yeah, or put it another way, get the inquest into what I did. A judge in that situation shouldn't.
Correct.
Unless the application is put on a very different basis.
Yep.
Make a decision which would have the effect of conferring immunity.
That's exactly right.
But you're not ruling out the possibility that in a case, I mean, none of this is absolute. In a particular case, it's not impossible for an insolvency office holder to come to court and say, on very particular facts, actually, we do want you to look into this.
Do you know, I can't think of one, and I haven't found one.
No. I'm not saying it's happened, but I'm saying
there's always the
you're not
exceptional case. There's nothing exceptional about this case. They were just selling off these highly paid court-appointed receivers were just selling assets.
But we come back then, don't we, to a point my lady made to you many times, that's made a number of times, which is what was the application for, and what was the scope of the application in the particular case.
Well, the scope of the application was to sell was to sell the assets the receiver could sell together with VBA's assets, and they got permission to do that. And it said nothing at all and the judge didn't come to any conclusion as to immunity. It said nothing at all about prof neg, and shouldn't have done. And then lastly, at paragraph 88 on page 17, this is where his lordship equates prof neg with fraud on the power in the first sentence, or first and second sentences. And they're two totally different concepts. I mean, he doesn't actually need to do this because he's already said that Nortel confers immunity for professional negligence as well. But then what he says in paragraph 88 is that prof neg is to be equated with some sort of a Wednesbury test on the power, and that's just not right at all. The whole issue about fraud on the power and per person vires is at my Lady Justice Asplin's higher level, and the prof neg is at a rather lower level, and they are totally different levels. Now, the last point that arises in these proceedings is my learned friend's alternative argument of abuse of process.
Well, hang on. He's focusing. Wait a minute. Paragraph 88. I mean, it's not an proposition of. He's commenting on your case, which you said you weren't going to take us to, but I was quite keen to look at, as to exactly what is the core of your allegation. And the core of your allegation, I think I read Mr. Justice Fancourt as saying, your allegation is that the receivers failed to achieve the best price because they should have sold the assets in a different way, i.e., we need to look at this. I understood that basically what you're saying is that they should have been sold separately. I mean, that's the core of the allegation.
But I have no issue as a matter of the higher level with the sale of everything together, including all the assets that the receivers sold and VBA's assets, which was the whole genesis of this application. I have no issue with that. I'm not challenging the transaction as a matter of vires or anything else. I'm simply saying that it was prof neg. It's absolutely a Nortel case in my submission, which is precisely the authority that was principally relied upon by the receivers and by Mr. Justice Marcus Smith. And if Nortel didn't give prof neg immunity, neither does this, and nor should it, and nor did it. And what is happening at paragraph 88 is really equating prof neg with matters of vires, which it does not. And his lordship finds that I have a properly arguable case, which as my learned friend's Part 24 failed a real prospect of success on, from paragraph 113 onwards, the merits grounds. I mean, he doesn't say it's absolutely a brilliant claim, but it's a claim which will otherwise go to trial, and the only reason it didn't is because his lordship found that what happened before Mr. Justice Marcus Smith, even though brought on purely public trustee and Cooper grounds and Nortel grounds, actually conferred much wider immunity in relation to tortious duties for the first time, as opposed to merely equitable ones, in a way that just doesn't happen in this field.
I'm sorry, so Mr. Collins, what did the office holders achieve, therefore, by the order made by Mr. Justice Marcus Smith, who, putting it as low as possible, decided that the assets in the schedule could be sold together as part of one transaction? What did they achieve by that?
Well, what they actually achieved was getting VBFA on board.
Well, okay.
No, lady, that's most important, because when they made the application, they had already made, the point had already made to them that they weren't going to be able to sell anything, while there was a prospect of Mr. Royston becoming a minority shareholder, which he would once he'd satisfied the judgment and acquired the shares. And that was the purpose of the application. Now, at that point, VBFA had not made any application, and it was at the hearing on the 14th of May, which we did not attend, that basically they were told to get on with it, and the order then provided for them to make an application to vary the order at the end of the 994,
Yes.
which they then did on the 15th of May. That's what was achieved, actually, by all of this, which was the whole purpose of it. They didn't need permission to sell assets because they'd been appointed as receivers in relation to all those assets in the order, and they could sell them. They didn't need permission to do that. But the only thing, and if they'd come to court and said, oh well, it's all a bit difficult. We'd like to sell for this price. Can you give us complete immunity from prof neg? The court would have said, no, we don't do that. This is not an exceptional case. You're just office holders doing a job, and you're well paid to do it, and go ahead and do it. We don't entertain applications of this sort. It's certainly not an exceptional case of the sort that my Lord Justice Snowden has suggested exists, which must exist, although we haven't found any of them. And so actually what was achieved was precisely what they wanted, was to get VBFA on board, and that was a vital part of the hearing before. We're talking about it only as a blessing hearing, but in fact the major part of the hearing was VBFA's application, and that's what I concentrated on, because that was the only thing actually that Mr. Royston, for whom I acted at that point, Denaxe being out of our control, had any real locus in relation to. So
I'm
that's,
sorry, thank you.
so
I'm
that's
sorry,
what
I
was
took you away. You were
achieved.
going on to abuse.
Well, very simply, if I am right that that the application for sanction before Mr. Justice Marcus Smith did not give rise to what the judge below found that it did, which was to extend it to professional negligence, the tortious duty of care in relation to office holders. If I'm right about that, and that it didn't and shouldn't, then it's obviously not an abusive process for me to try to argue a professional negligence claim on a public trustee and Cooper application. And if it did grant immunity, according to my learned friend, then the case goes without him having to rely on Henderson and Henderson, because he's got immunity from it. So it doesn't add anything. It's all about immunity. If it's any consolation, I think I'm a little ahead of the schedule that we prepared, but those are my submissions, at least for the moment.
Thank you very much indeed, Mr. Collins.
Can you just identify, just some for my notes?
Yes.
What's the reference in your pleading of professional negligence is in core bundle, isn't it? In paragraph 113, I think, of the judgment,
Yes.
it's been looking at Mr. Justice Fancourt, as it was summarised via Mr. Moyden's submissions, what your case was.
Yes.
Can you actually just give me the reference to where your case in professional negligence is actually spelled out?
Yes. Starts on page 138 of the core bundle. And it's A to E.
Oh, so hardly. So it's E, really, is it?
Well, no, actually, not when one looks at all the material and the other valuations that there were of the stadium and so on, and we get into this whole issue of the Collier's valuation. I mean, we had hours of this in front of Mr. Justice Fancourt, and I got sufficient approbation to go ahead with it. And to be honest, I'm not really in a position to sort of re-argue all of that. But it's all set out in our Skeleton argument below, which is in the supplementary bundle, as is all the material that was before Mr. Justice Fancourt, and he dealt with it reasonably shortly, from paragraphs 113 just over the page in his judgment. And I have a properly arguable claim of prof neg against these receivers in relation to the sale of these assets, for a claim brought by the company, which I'm now back in charge of. So I'm in a position to be able both to investigate and bring the claim, which I've done. pursuant to the window afforded me under IRC and Hoopercroft, and by the order discharging the receivership, and without the need to get the permission of the court as per your lordship's judgment in Manchester.
Just to go back to what the core of your claim is, Mr. Justice Fancourt does treat it, as I understand it, as being an allegation that what should have been done is a separate sale. Separate sales of different assets. He, in the paragraphs you've just referred us to, that's what he's talking about. I'm looking from page 21. I thought that's also what you said earlier, that that's what the critical part of the claim was.
Yes, I mean, it's paragraph 114.
Thank you.
Didn't consider alternative strategies.
Well, I'm looking at paragraph 113.
Yes, and 114 is where his lordship really comes to his conclusion.
But you don't take issue with what the judge is saying in those paragraphs?
No. Well,
Okay.
no. I mean, this was on a Part 24 application.
Yes.
And of course, matters will be very much traversed in relation to the Part 7 process as it unfolds before trial, and of course things may change or augment, or as the case may be.
But the
But I
summary,
have a properly arguable case.
yeah, but the summary, to pick up my lady's point, I mean, these are the paragraphs that you just referred us to,
Yes.
where the judge says, yes, you've got an arguable case in
Yes.
professional negligence, but the core of it, and it's particularly obvious from 114
Yes.
to 116, is that the receivers didn't consider an alternative strategy of marketing the property separately rather than as
Yes.
a whole.
Knocking it down and building an Asda superstore.
That's the core of it.
Yes. At this stage, yes.
And so when it goes back to a point I made very early in the hearing, when Mr. Justice Fancourt talks about the club being sold as a going concern in 114, he's using that word to mean all of the assets,
Car
footballing
park,
assets,
training ground
car
some
park,
miles away.
everything.
Yes, I mean, no consideration of selling that off separately.
And
Planning or whatever.
with the shares as well. That is,
BBFA shares.
yes.
Yes, that's right. I mean, they were always going to try and sell everything together. I mean, that was, if you look back at the judgment that was upon which they were appointed, their strategy has always been to sell everything together. And so there's nothing new or incredible about that. And it's just a sale of assets in a bundle, and that's what IPs do. The important thing, though, which was going to kibosh it, was VBFA shares. And that's why they made the application.
Stripping aside allegations such as, you know, that maybe they didn't advertise it for long enough, or this, that, or the other, which are sort of smaller, of which that we've got no particulars. I mean, the core allegation that Mr. Justice Fancourt focused on is this question of composite sale or no composite sale.
Yes. Yes. He also dealt with the fact, in relation to all of this, that even with that there are also issues about delaying sales and that sort of thing. He covers that in his judgment as well, about whether sales were delayed. And I can't remember that is.
Well, although that's not actually one of your particulars of breach of duty.
No. I mean, I mean, this case may evolve as we learn more about this from the litigation procedure, which is what it's all about. We didn't conduct this sale. We have a real prospect of success on the allegations that we have made. But as matters emerge and we're able to interrogate the matter more, the case may evolve. That's the nature of Part 7. I mean, we're at a very, this case is in its infancy, and indeed has been cut off in its infancy.
The suggestion that something may turn up never has had much traction on
not on a
applications.
not on a Part 24. But I didn't need that. I've got through that hurdle, and it may well.
Yeah, well, we have to look, don't we, at the allegations that are currently made, and the scope of whether your current claim, as formulated, falls within such immunity as flowed from what Mr. Justice Marcus Smith decided.
Yes, his lordship not having done so, and his lordship having approached the matter on a public trustee in Cooper, that limited public trustee in Cooper basis, with the vital ingredient, which is what was the genesis of the whole thing, of VBFA shareholding. They'd never have come to court for approbation for a sale without that, without the issue of VBFA shareholding. Had they done so, the court would have said, no, you go away and do the job for which you're being remunerated to the tune of £800,000 plus VAT. Thank you very much, my ladies and my lord.
Thank you, Mr. Collins. Mr. Morrow.
My ladies, my lord, thank you. I wonder if it might help if I start by taking you to the claim as formulated when the matter came before Mr. Justice Fancourt, which I propose to do by reference to the draft amended particulars of claim, which was the basis upon which he considered the application that I made to him. And you will find those in the core bundle, tab 50. That should be page 120 of your bundle. I'm going to do this slightly backwards because of the way this pleading works. If you'll forgive me, bear with me for a few moments, I'll take you through it. If one turns, please, to the allegations of breach, which one sees pleaded at the bottom of 138, paragraph 54 in the amended numbering. And what's pleaded there is this. As a result of the matters complained of above, and that's why I'm starting here, because I'm going to have to go back to what's complained of, the defendants were in breach of their duties set out at paragraphs 31 and 32 above, in that they, and then we have A to E at the top of 139, which have already been shown. Can I then take you to what is pleaded above, if I may? And that is at paragraph 40 on page 134. That recites the applications that came before Mr. Justice Marcus Smith, the completion of the sale. We then have deleted the complaint that was previously made about not reoffering assets to previous offerers, no steps to market on the basis that effectively the entire issued share capital was available. We took issues with those in our defence first time round, but then we get this that remains. Further, no attempts were made to offer the property assets for sale separately to the shares in BFC itself. Then we get the complaint as to the value of those shares at 41, those assets at 41, the £59.7 million claim in respect to the shares having been deleted. We get the complaint at 42, perhaps more neutrally put, the recital at 42, that the sale of the entire issued share capital in BFC, that's the limited club company, excluding the 3.7 shares, they were mostly held by supporters. The entire issued share capital in the hotel, the stadium, the training ground, and two of the properties for 8.2 million. And then, my ladies and my lord, if you turn the pages 135 and 136 struck out, we then get a plea to shortfall, we then get a recital of the discharge of receivership, a complaint about material not having been return, and we then get to the breach of duty particulars, which is where I started my process of showing you what was in the draft amended particulars of claim. And the short point that I come to then, and forgive me and thank you for bearing with me to this point, is that the complaint is only no attempts were made to offer the property assets for sale separately to the shares in BLC itself. That is the complaint, the single complaint. Whether it actually gives rise to the particulars pleaded on page 139 is a different question that I needn't dwell on, save for E, which is where it is picked up as an allegation of breach. May I respectfully pick up my Lord Justice Snowden's point that you have to consider the claim as it is presently formulated.
And you need to go also just, I mean, you may be about to take us to it, but I'm sorry if you are. The particulars of loss and damage are at page 140.
They are.
And the only material, as I understand it, one that's extant, is in paragraph 55A. I mean, there are, I understand it, in any event, other things that are going on in the county court, whatever, but that's the key particular of loss.
So A is the only particular of loss that's relevant for you, because those at B, C, D and E.
And since you say that the allegations of breach in relation to marketing have gone, is that right?
Well,
Well, there's a particular is alleged. You can see that at the top of 139. For example, B, failed to undertake proper marketing. But that is as a result of the matters complained of above. And when one goes above, one can only find a complaint that no attempts were made to offer the property assets for sale separately. On that marketing point, we go up to 36 on page 133, my lord, and what you see there is an allegation crossed out that Hilco, they were a third party instructed by the receivers, produced inadequate marketing material for which they charged significant sums. And so, my lord, you're quite right to observe, if I might say so, that the only loss that's claimed that's relevant for this appeal is the loss that is alleged to arise, being the difference between the value obtained for the assets, and that's the 8.2 million, and the price which ought to have been obtained if the assets had been sold separately, proper marketing. The with proper marketing part is slightly confusing at that point, but I think my point still holds good. For completeness, B, C and D are the matters that are going on in the Manchester County Court that I don't need to trouble you with, and E, I say, adds absolutely nothing. If I may then, to pick up my Lord Justice Snowden's point, you have to consider the claim as it is currently formulated, not speculating as to what might evolve, whether there might be some claim that these receivers should have engaged in some sort of planning permission process, which seems remarkably unlikely that that sort of allegation would have any merit anyway, or that there should have been some sort of knockdown and rebuilding, which again seems remarkably unlikely. My ladies, my lord, that being the state of the claim, can I then go, and this is a shortcut that might save me going through all the points I otherwise have to make, to my Lord Mr. Justice Fancourt's decision below. You'll find it, and I know you've seen it, at tab 1 of the core bundle. May I take you to paragraph 80. Of course, we say Mr. Justice Fancourt was right. But I wonder whether I can shortcut through picking up on my Lord Justice Snowden's point about the source of the duty and whether that matters, and I can deal with all that if I need to. Shortcut through by taking you to this, in the words of Mr. Justice Fancourt 80. The fact and extent of immunity derives in principle from two matters. The nature of the review conducted by the court, now that must be a reference on the facts of this case to Mr. Justice Marcus Smith, and the decision that the court approves. What I'm going to say about that is the decision that the court approved was the sale to Mr. Sadler with the detailed information that was put before Mr. Justice Marcus Smith. Going back to paragraph 80, whether immunity extends to the particular claim brought depends on what allegations are made or necessarily involved in the claim. And that's why I took you, forgive me laboriously, through the draft amendment of the claim. The next paragraph to draw to your attention is paragraph 86. That's page 16, and it reads this. If the court approves an office holder's decision to enter into a specific sale, as was the case here, a person affected cannot allege a breach of duty by not retaining the asset or not selling it in a different way to someone else or for a higher price. Such claims necessarily involve an allegation that it was wrong to decide to sell the asset in the way that the court has authorised. May I then go to 88 over the page, 17. The receivers can only have failed to achieve the best price for the footballing assets if they should have sold the assets in a different way. What is therefore being alleged that the sale was a wrongful exercise of the receiver's powers. Subpowers A to E are the reasons why the receivers failed to achieve the best price. That's the particulars of breach I've shown you. It is the allegation of failure to achieve the best price, which is a substantive complaint that allegedly caused over £25 million of loss. The receiver's decision to exercise their power over footballing assets and the VB shares to Mr. Sandler at a price of £8.2 million was the very decision that the court approved, and the receivers have immunity to the allegation that they should have sold in a different way at a higher price. I'm then going to ask you, because it would be painful for you, I think, to hear me read it out, to read paragraphs 89 to 94. I'm very grateful. The submission I'm going to make picks up with respect points made by my Lady Justice Asplin and by my Lord in an exchange with my learned friend. Leave aside the nice debate we could have about the source of the duty, what it is, and how it might apply, and look actually at what was asked for, what was put before Mr. Justice Marcus Smith, and what the claim now being advanced involves. And the point that emerges is that what is now being said was all part and parcel of the transaction that was put before Mr. Justice Marcus Smith on the 5th of June 2019 and which he approved. And so this is one of those situations where sufficient information is put before Mr. Justice Marcus Smith to enable me to submit to Mr. Justice Fancourt and for him to conclude that there was immunity from a challenge, and I use the word deliberately, as being a broad word, to the very transaction in question. The claim that my learned friend wishes to advance is that challenge.
I mean, putting it the way you've just put it, putting it the way Mr. Justice Fancourt put it at paragraph 86, puts it very high, doesn't it? In the sense that I'm not sure quite what the basis for 86 is. Is he saying it is a matter of law that follows, or is he saying that it may follow depending on what was asked for and what was put in front of the judge? Because I understand your submission, you look at what was asked for and what was put before the judge and then compare it with the claim that's now advanced. But if I ask myself to go, let's just take the facts of Nortel, which you'll come on to. I mean, Nortel was a specific transaction that was being asked to be entered into. But I can be absolutely sure on this, there was no way that I was in a position to go into, nor would any other judge, be in a position to unpick the course of negotiations that led to that compromise, so as to say that nobody had acted carelessly at some point throughout that long and elaborate process. I'm just wondering whether it's right to be focusing on, if you have an approval to enter into a specific sale, that these propositions follow as a matter of law or course. There's a more nuanced way of putting it, which is, I thought, the way you were putting it, and I don't think they're quite the same, which is, look what is asked for, look at what is put in front of the court, and you might say the court should be very clear about, therefore, what it is being asked to do. And then the immunity might follow from that clarity, rather than just by simply saying, well, it's a sale. If you approve a specific sale, it follows as a matter of course that you get immunity for everything that he's listed in paragraph 86.
Well, although I do put it in that more nuanced way. And I do that because my submission picks up my Lord's point made to my learned friend, that there may be a situation, I say this is one of those situations, where it is possible to put enough material before the court in order for that immunity to flow. I appreciate I've short-circuited through the steps. So I do put it in that more nuanced way. And well, there's nothing wrong with that approach. It sits with all the points that have been made in my submission about public trustee and Cooper, as applied in this, on the facts of this case, not insolvency context. This is not an insolvency office holder case. This is a case about officers of the court. And I know on this side we've used the phrase office holder in our skeleton, and we were wrong to do so. It's fairly plain in my submission that these receivers are not office holders in the sense meant by the 1986 insolvency.
Well, I think you both strayed from the straight and narrow in that respect. Mr. Collins, paragraph 5.4 also does, but anyway, I think everybody understands that office holder to insolvency lawyers has a very specific meaning.
Indeed.
But undoubtedly receivers appointed by the court are officers of the court.
Yes. Yes. So what I was going to do then was go to the application that was made to Mr. Justice Marcus Smith. And I know you've been taken through it, but there are some inevitably different points of emphasis that I wish to raise. So what I propose to do then is take you back into, and forgive me, the application itself, which is at supplemental bundle tab 3. And the point I'm going to make is that it was plain by the time the matter came on for hearing on the 5th of June exactly what it was that was being asked for from Mr. Justice Marcus Smith. This is the application notice of the receivers. Paragraph 1 is the relevant part. Sell the assets in the schedule attached as part of one transaction. I don't think there's any dispute about what those assets were, so I don't think I need to dwell on that. Mr. Cooper's witness statement, the first one you've been taken to, I don't need to dwell on that with you. The confidential exhibit at tab 5 is again not particularly relevant right now.
Well, I mean, what Mr. Collins placed reliance upon is paragraph 29 at page 24, which is Mr. Cooper's witness statement, and the words in particular, it is for this reason that the receivers are making the application.
Well, my point is, my submission is going to be that by the time it came on for hearing, it was blindingly obvious what was going on. And I'm going to seek to add to Mr. Cooper's first witness statement at 29 by going to his, I think, third witness statement, page 75, tab 13, paragraph 15. Where his final shot is to reiterate his confidence in Mr. Sadler's offer. So that's a direct reference back to what elsewhere was referred to as bid 1. The building blocks of that submission, that's one of them. The other building blocks are...
But also there, sorry to interrupt you, he says, must be sold together to facilitate a global sale of all the football assets as a going concern.
Yes.
So he's encapsulated it all there.
Yes, my lady, thank you. My respectfully adopt that point. The building blocks. There's Mr. Oyston's witness statement of the 28th of May. The paragraph is page 58. The last paragraph, 8. This is the assertion he makes that the present application's clause are limited to mechanics. That's why I have not commented on the evidence as to marketing values to which my rights are reserved. Now that's met.
Sorry, I've missed that reference.
Forgive me. Tab 10 of the supplemental bundle.
Going backwards, sorry. Yeah, thank you.
And page 58. Paragraph 8. That is met with the letter that you've already seen from Stevenson Harwood, page 59. It's the next tab. 29th of May. And it's the second sentence of the second paragraph, which, as you heard, met with no response. We then have the skeleton argument of the applicant. So that's the receivers. That's tab 12, page 61. There's a heading on page 62B, Introduction and Overview. Para 2, filed on behalf of the applicant in support of the application for direction that they may sell together or as part of one transaction. Then list 1 through to 8, defined as the football assets, over the page 9, BBFA's shares, compendiously defined as the sale assets. I've already shown you Mr. Cooper's third witness statement. There's then finally on this point, as to what was known by the time of the hearing, the skeleton argument of Mr. Royston. That's tab 14, page 77 is where it starts, and the paragraph I want to direct you to is 2.4, bottom of 78 over to 79. What you have there is a reference to the Stevenson-Harwood letter, seeking to widen the scope of the application to a direction that the receivers enter into a specific sale transaction. What follows is why that's objectionable on the learned friend's case. So first there's his, well, this is just a commercial question point. And then the court is understandably reluctant to become involved in commercial matters. And then he says, third, if what they want, the receivers, is in effect protection against any allegation of professional negligence, it behoves them to say so clearly, so that those concerned may file evidence accordingly. Mr. Royston's evidence did not address the substance of the proposed sale, because the application notice only sought a direction as to mechanics, not merit. And so the matter comes on before Mr. Justice Marcus Smith on the 5th of June 2019, and in my submission when it does, it is, you'll forgive the phrase plain as a pikestaff, what it is that is being sought. You have in your bundle the transcript of that hearing. I think it would be painful all round were I to take you through that in any detail, so I'm going to go straight to the judgment of Mr. Justice Marcus Smith, so that you can see what it is he did. There is, forgive me, I'm going to say this reasonably slowly, but I do know the time. The recital of the background over 13, having recited the background and the failure by the respondents to the 994 petition to pay the sum they'd been ordered, and the failure, lack of success in enforcement, we get the appointment of receivers. Then at 14, at the top of page 85, receivers were appointed over the footballing assets, by which I meant the assets related to or relating to the fourth respondent. Forgive me. It's necessary to use the terms elliptical as assets related to or relating to the fourth respondent, because the fourth respondent does not itself actually own all the assets it needs to operate a football club. It doesn't own, for instance, own the ground at which it plays, which is owned by Segesta. Segesta is a previous name of the claimant. That might assist with my Lord's point about what is meant by the term club, which is why I've dwelt on it there. There's then a further recital of background, moving into the evidence, the reference to the role of Mr. Royston and or his family at paragraph 20 of the judgment, and then we come on over at page 87, paragraph 25, to the outcome of the sales process described by Mr. Cooper. Then the bids are referred to.
I'm sorry, I'm back at 17, just for a moment. The judge mentions what he's defining as the club,
Yes.
and then he says, it's always been felt, as my ruling of the 13th of February makes clear, and as the receiver's evidence before me today confirms that a better price could be obtained by selling the club as a going concern rather than by selling the receivership assets separately in an asset sale.
Yes.
So there was evidence to that effect before Mr. Justice Marcus Smith. I'm sorry to have stopped you.
Not at all.
Where were you? Where were you? I'm sorry.
Forgive me. If it would help, over lunchtime we'll find the references back into the evidence before Mr. Justice Marcus
That
Smith.
would be helpful, thank you.
Forgive me.
That you had gone on, quite rightly.
Not at all. The bids starting at 25 on page 87, then at the top of 88, paragraph 29, receiver's position that bidder 1 is the preferred bidder, and the explanation, reference to the urgency, which is relevant on this type of application. Then what happened after an exclusivity arrangement had been entered into with bidder 1, and why a late bid was rejected. And then, over on page 90 at paragraph 36, more detail about bid 1. And then, Mr. Justice Marcus Smith sets out 3 questions. 1, whether the receivers actually need the approval of the court to proceed with the sale to bidder 1. Secondly, how the shares in the 4th respondent, which are registered in VBFA's name, should be dealt with, and whether the buyout order could be revisited. The learned friend's entirely right. From reading the transcript, it can be seen that was controversial. And then thirdly, assuming the answer to my first question is yes, the receivers should properly come before the court, and the second question is satisfactorily resolved, should the sale then be approved? He then, 38, goes to the first question, and he deals with the submission made by the learned friend that court approval was not required. And the point that was taken there was that the obligation in paragraph 18 of the receivership order, set out paragraph 39 of this judgment, strictly did not apply. But what Mr. Justice Marcus Smith concludes at 41 is this. However, the fact that, technically speaking, paragraph 18 does not apply to the assets the receivers are seeking to sell is, to my mind, missing the point. The existence of paragraph 18 underlines the wider point that I regard the sale of the club as a matter requiring court scrutiny, as indeed I do. I'm going to pause there before we get into the analogy. The submission I want to make at this point is this. That is a decision that was reached between the parties that appear before you today. It's a decision that binds them. It's not a decision that has been appealed.
What does it mean, requiring?
In paragraph 41, I think that's an echo of the, as I understand it, an echo of the point of paragraph 18 of the receivership order. So if my lord goes back to paragraph 39...
Well, no, he's talking about a wider point.
Yes.
He says the existence of paragraph 18 underlines the wider point I regard the sale of the club as a matter requiring court scrutiny.
My understanding, my lord, is that this was for the protection of the respondents to the 994 petition, so that they understood the court had seen the terms upon which any sale was proposed to take place.
So you're saying that, in fact, however it's expressed, he's really just talking about the vires point there of are the receivers able to do it within the scope of the existing orders? Because they're trying to sell the shares.
Well, look, the wider point in my submission is a subject matter of what the court, of the scrutiny. So at paragraph 18 of the receivership order, the subject matter of the scrutiny is expressed to be the second respondents, that's Mr. Royston, at 1.6 million ordinary shares in the claimant. Now that's not the transaction that came before Mr. Justice Marcus Smith. Of course, what was being sold were the shares in the first respondent.
So you're saying the terms of the receivership order signalled that the court wanted to have a look at the details of the sale transaction. As it happened, the subject matter of the sale is a different asset or asset.
That's exactly it.
Okay.
That's what I, in my submission, meant by requiring a matter requiring court scrutiny in paragraph 41. So the submissions that the learned friend made about, well, these receivers could have just got on with this anyway. They've got a power of sale, they just do it, is met by this point that they had to, as decided by Mr. Justice Marcus Smith, come back to him, which they did. I've got other points to make about the Montin line of authority, so I can come to it this afternoon.
So, just let me get this right. Are you saying that paragraph 18, which I must admit I haven't focused on, my apologies, but paragraph 18 of the order, you say envisaged that if there was to be a sale by the receiver of Mr. Oyston's shares, that the court wanted to approve the terms of that sale?
Can I show you paragraph 18?
Well, I can see. I mean, I can see
It's
it.
at
Yes.
39.
It's at 39.
Yes.
And you're saying that, in a sense, from there flows the willingness or the sense that the court was required to look at the actual terms of the sale.
Yes. On the facts of this case.
I mean, it doesn't answer, in the sense, for what purpose or with what level of scrutiny, but you're saying this is an unusual case where the actual power of sale given to the receiver envisaged that there would necessarily have to be some approval or scrutiny of the terms by the court.
Yes.
You're linking it to the obvious background of the 994
Yeah.
proceedings.
Yes.
Which is perhaps the judge's wider point in the third line of 41.
Indeed. Suffice it to say, you've seen I'm not suggesting you ought to read it, you'll have seen the length of Mr. Justice Marcus Smith's judgment in the 994 petition. Now, I wasn't involved, but it's fairly obvious it was bad-tempered and controversial, to say the least. I wonder, I'm looking at the clock, I'm not going to finish in the next 3 minutes, I'm afraid, whether that might be a convenient moment for you.
That's fine. Thank you very much indeed. We'll begin again at 2 o'clock.
Very grateful.
All right.